Stephen A. Bennett built his career as a senior management analyst at the Federal Reserve Board. His specific professional mandate was to analyze large volumes of complex data and identify material signals that others missed. When the board announced its COVID-19 vaccination mandate, Bennett applied those exact analytical skills to the regulatory record. As an active cancer patient, he submitted an exemption request based on his analysis of the vaccine's legal authorization status. The board rejected his analysis and terminated his employment. In response, Bennett filed a federal lawsuit against the United States. He sought damages under the Federal Tort Claims Act, or FTCA, holding the Department of Health and Human Services, the FDA, and the CDC liable for his termination. The federal government cannot be sued unless it explicitly grants permission. The statutes governing this permission define the narrow circumstances under which the United States waives its sovereign immunity. Bypassing these statutory shields requires a specific pleading strategy. A plaintiff must take broad agency guidance and legally recast it as a non-discretionary ministerial failure. Surviving the FTCA is not determined by the severity of the government's action. It depends on the precision used to plead the government's legal duty. To build that duty, we have to establish the exact regulatory framework at play. Under Title 21 of the United States Code, Section 360 BBB-3 defines an emergency use authorization, or EUA. Products under this category are legally classified as investigational. Conversely, Section 355 of the same title defines a biologics license application, or BLA. This classification denotes a fully approved, licensed product that has completed the full clinical review process. The difference between these two classifications dictates strict legal requirements. Federal law mandates that individuals offered an EUA product must be informed of its investigational nature and advised of their right to refuse the intervention. Bennett's core grievance is that official public guidance from HHS and the FDA conflated these distinct regulatory statuses. The agencies labeled the available investigational vaccines as FDA approved. Looking at the label text on these two vials, we see the physical proof of that legal boundary. The fully licensed BLA product, Comirnaty, and the EUA product actually administered to the public were legally distinct entities operating under separate authorizations. As the Federal Reserve Board implemented its mandate, it relied on that conflated HHS guidance. When Bennett submitted his analysis detailing the legal difference, the agency cited the FDA-approved agency messaging and dismissed his exemption request without substantive engagement. This mandate overrode the direct clinical recommendation of Bennett's treating physician, who had supplied a letter advising him to avoid immunizations during his active cancer treatment. Conflating EUA and BLA statuses carries precise legal consequences. By obscuring the investigational nature of the available product, the government's guidance stripped individuals of their statutory right to informed refusal, guaranteed under federal regulations. The first major barrier to any FTCA claim is Title 28, Section 2680A, known as the discretionary function exception. This statute is designed to prevent the judicial branch from second-guessing the social, economic, and political policy choices made by federal agencies. Courts apply a two-pronged standard, known as the Galbert test, to determine if the government's conduct is protected by this exception. Prong 1 asks a simple question: did the challenged conduct involve an element of judgment or choice by the agency? If yes, Prong 2 asks if that specific judgment was the kind of decision the exception was designed to protect, meaning, was it grounded in public policy considerations? Federal agencies routinely defend their pandemic guidance under this test by framing public health messaging as a weighing of policy trade-offs, shielding it from liability. Bennett's complaint deploys a strategic counterargument. It asserts that the guidance in question was not a policy choice at all, but rather a failure to accurately report a fixed regulatory fact. Under 21 U.S.C. Section 393B, the FDA has a statutory ministerial duty to ensure accuracy regarding the products it regulates. Because the FDA had already classified the available vaccine under an emergency use authorization in its own internal records, communicating that status accurately left the agency with no rightful option to obscure it in downstream guidance. By framing the agency's action as a ministerial reporting failure regarding an established fact, the pleading is designed to bypass the Galbert policy shield. There is no policy discretion in misstating your own fixed records. The second major hurdle is Section 2680H, the misrepresentation exception, which bars claims arising out of deceit or misrepresentation. This creates a structural paradox. Bennett's injury stems from relying on the government's false statement that the mandated vaccine was FDA approved. Under a Supreme Court precedent known as United States v. Neustadt, any claim that relies entirely on a discrete false statement, like an isolated property appraisal, is barred from proceeding. To navigate the Neustadt trap, the plaintiff pivots to a different precedent, Block v. Neal. The Block standard establishes that liability is permitted if the government breached an independent duty to perform an ongoing task with due care. Even if a misrepresentation is involved, the operational failure takes precedence. This ties into the Indian towing principle. The federal government does not have to operate a lighthouse, but once it undertakes the task of doing so, it assumes a legal duty to perform that task reasonably. The complaint maps this exact analogy to HHS. The agency voluntarily undertook the operational task of defining vaccine regulatory status and providing that guidance to federal employers. The tort alleged here is not a single lie spoken on a single day. It is the ongoing failure to maintain and correct the federal guidance apparatus, as employers relied on those inaccuracies against their workforce. The claim is structured to survive the misrepresentation exception by shifting the legal focus away from the words spoken and onto the system negligently operated. The final procedural hurdle is proving Article 3 standing. A plaintiff must demonstrate a non-speculative chain of causation between the government's action and the personal injury. The Supreme Court set a rigid standard in FDA v. Alliance for Hippocratic Medicine. Plaintiffs cannot sue over federal guidance if their injury relies on the unpredictable reactions of third parties. HHS did not fire Bennett. The Federal Reserve Board did. To establish standing, the plaintiff must prove that the board's enforcement of HHS guidance was predictable, not an independent exercise of third-party discretion. The complaint maps this out in 3 nodes. Node 1. The FDA originates the regulatory classification. Node 2. The CDC and the Safer Federal Workforce Task Force disseminate this classification as universal guidance. Node 3. The Federal Reserve Board consumes this guidance as an intended implementer operating within the federal apparatus. The link between these nodes is a matter of documented record. The complaint details specific dates where the board invoked the phrase FDA approved and cited CDC guidelines in writing to deny the plaintiff's exemption. Standing is sought because the guidance is not treated as a nebulous public broadcast. It is mapped as a documented administrative loop designed to force employee compliance. This pleading is architected to navigate a severe procedural gauntlet. It is structured to bypass the discretionary function exception, address the misrepresentation exception, and establish a predictable causal chain for Article 3 standing. The underlying violation driving this litigation is the betrayal of 45 CFR Part 46, the codified regulations strictly mandating the protection of human subjects from uninformed medical intervention. The text highlights a stark legal asymmetry. The Department of Justice recently moved to dismiss charges against individuals who falsified vaccine cards, while punishing a plaintiff for executing a transparent, documented, and legally accurate objection. This leaves the federal judiciary with a precise, unadjudicated legal question. Is federal guidance actionable under the FTCA when it misrepresents the regulatory status of an investigational product in direct violation of the agency's own informed consent regulations? Bennett v. United States is a meticulously constructed blueprint, demonstrating how civil litigants can map administrative procedure against tort law to hold federal agencies accountable for their guidance.